Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. Now, without any further ado, it is my distinct pleasure to welcome our 2 speakers this afternoon, beginning with Geri Green. Geri has been a full-time mediator and discovery referee since 2015, mediating cases in the areas of personal injury, malpractice, employment, business, real estate, construction defect, insurance coverage, and civil rights. Geri served as a mediator, settlement conference officer, and discovery judge pro tem for San Francisco, Contra Costa, and Marin Superior Courts, and the 3rd District Court of Appeal, and the Eastern District. As a litigator, she worked on both sides of the aisle, trying more than 100 cases and authoring hundreds of appeals. She's a frequent presenter on ADR and discovery-related issues and works with business leaders developing sexual harassment training protocols. She's a founding member of the Bay Area Legal Incubator Brain Trust Development Programs. Of the Bay Area Legal Incubator Brain Trust, developing programs on ADR and business development, and she has extensive training and experience in conflict resolution, trauma, and cross-cultural competency, holding an LLM in international law. Thanks so much for being here today, Geri.
Thank you, Katie. Hello, everybody.
Our other speaker this afternoon is Justice Patricia Benke. Justice Benke is a trailblazing jurist who served as an Associate Justice of the California Court of Appeal 4th Appellate District, Division 1 for 34 years. Appointed at just 37 years old, she was the first woman to serve on her court. Justice Benke's distinguished career includes roles as Deputy Attorney General, Municipal Court Judge, and Superior Court Judge. Beyond her judicial service, she's an award-winning author and a recipient of numerous accolades, including the Napoleon A. Jones Jr. Award for Judicial Excellence. And she's now available as a neutral with ADR Services, Inc., brand new member. Thank you for joining us today, Justice Benke.
Thank you, and I'm happy to be here, and hello, everybody.
All right, so now I will turn the program over to Geri to get us underway this afternoon.
Well, thank you, Katie. I know everybody's been going for a couple of days and we're late in the program, so I thought we'd go back in time for a moment and think about a different time, 1990 to be exact. And could you change the slide, Katie? There we are. Great. Because things have changed so much, and in some ways they haven't changed at all, or certainly not enough. So I want you to think about imagining 1990. Back then, the ABA, American Bar Association, our group, offered medical insurance to lawyers here in California. They don't do it anymore. We'll see why in a minute. When I found out I was pregnant with twins in 1990, I had an ABA medical insurance policy. I had gone into law school and, I checked, I probably looked at the terms and probably noticed that it covered pregnancy, but I can't really tell you that I read all the fine print. In fact, I know I didn't, because when I went to the doctor, got diagnosed with a twin pregnancy and submitted my claim to the insurer said, "Oh, we only cover the lawyer's spouse's pregnancy, not the lawyer's pregnancy." So, it was a very difficult time. I was horrified. I couldn't believe that in 1990 that could happen, that was still the case, since in 1983, when I was in law school, 40% of the class were women. But nonetheless, the American Bar Association's insurance policy was just for cover the lawyer's spouse's pregnancy. They never actually covered in California the lawyer's pregnancy, to my knowledge. They just stopped providing coverage at all. So fast forward 34 years to where we are today, a lot has changed. Today, women, since 2016 has been deemed by the ABA the decade of the female lawyer, where last year, in 2024, 56.2% of law students were women. 51.5% of federal government lawyers were women. 50.3% of law firm associates were women, and 49.2% of full-time law school faculty are women. We are now in the majority of who are moving into the space of being lawyers. So the practice has to, I would hope, finally recognize that they need to deal with our issues, women issues that affect everyone, but disproportionately, certain things disproportionately affect women, such as pregnancy. So
if I could join in here, Geri, because we've
yeah.
talked about this in preparing this program. At the outset, when I look at this entire problem, this question of bias, defining what we mean by bias and to whom that applies is really important, because you're going to see that the focus is on women because of sheer numbers as we move along. But the question of bias, as disproportionate problems are created for women, applies to everyone. And Geri just said that, and I think that's so important, that what we're talking about are problems within our profession. It comes out in the form of women, but it's subtle, but it applies to everybody. So I wanted to add that, Geri, because I thought that was a great comment you made.
Well, absolutely. Thank you, Justice Benke. That as we'll see as we go through some of the data, the problems exist for the legal profession at all. They just disproportionately affect women, and it might be because we're now in the majority. So we're being disproportionately affected. But a lot of it affects younger lawyers, lawyers of color, all sorts of different issues that arise. Bias affects all of us, but it certainly disproportionately affects women because there are so many of us. There was something I was thinking about this last night as I was preparing. I don't know if anybody has read Carolyn Criado Perez's book, The Invisible Woman, but there she talks about how so much science is based on all the medical tests, and seatbelt tests are based on the default human, which is a man. I think now that women are in the majority as lawyers, the default lawyer maybe should be women. And we should be thinking about, when we look at these numbers going forward, that even when we say X number of lawyers are affected by this, default lawyers are in the majority women. So I thought that was, maybe we have to think about how we look at things. We could go to the next slide. One of the other things that happened in 2016, in addition to beginning the decade of the female lawyer, the ABA researcher Patrick Krill conducted a nationwide study on the state of attorney well-being. And the results, as you probably all recall, and I think it's been talked about during our program this last couple of days, were shocking. Attorneys have higher rates of alcohol, mental health issues versus other professionals. A 20%, like double, 20% to 11%. Attorneys in their first 10 years of practice are at the highest risk of drinking problems. Attorneys climbing up the ladder are at the most risk. Attorneys experience depression, anxiety, and stress at higher rates than other professionals. And it decreases with the number of years in practice. Now, that could be because the breakdown of who's practicing, who the older lawyers are not women for the most part. When I was recently doing research for a presentation on substance abuse and competence, I came to realize that the immense toll that that old law profession bias that I had experienced in 1990 was now taking on women. You may have seen some of the data yesterday in Will Hickey's program. The competence data is very troubling. The business of law, the legal industry, is sickening and depleting its one and only product, legal services itself. And that depletion is disproportionately affecting women. In fact, in 2024, there was a last year, Forbes did a study on a happiness scale of industries, and the legal industry was at the bottom. A grim reality 8 to 9 years after the American Bar Association highlighted the extraordinary risks of mental health and substance use disorders among attorneys. We could go to the next slide. In 2021, 5 years later, Patrick Krill did another study. This was for the California and the DC bar. He called it Stress, Drink, Leave, and it was an examination of gender-specific risk factors and attrition among lawyers. And particularly, and what he found was that women are significantly impacted. They have more mental distress, greater levels of overcommitment and work-family conflict, lower prospects of promotion than their male counterparts. And this is despite the fact that women are comprising a majority of law students and associates. They continue to face disproportionate challenges. 1 in 4 female lawyers consider leaving the profession. As you are looking at them right now, they are considering leaving the profession due to mental health problems, burnout, or stress. And it's not just women alone. The law practice is sickening men as well. 17% of male lawyers are considering leaving as well.
I think that's another important point, Geri, that you mentioned, that when you have a system like law that is reflective of our culture, they're not quite meshing together. And so this is a lot of what we get, that your comments that definitely go to.
Right. That, it is, the profession at all is struggling. And what we're seeing, the next slide represents this, if we go to the next one, that we are all suffering. Women are suffering more, but we are all suffering. And it shows here, I put this slide in here because I want all of the people listening, everybody here, to know that you're not alone. If you are sitting in your office feeling overwhelmed and helpless and hopeless, you are not alone. 30% of women and 16% of men are feeling this of depression. 23% of women are anxious and 15% of men. And the numbers for risky and hazardous disordered drinking are even more concerning. 60% of women are engaging in risky drinking, with 46% of men. These are signs that the profession itself has some work to do. We are struggling, all of us. We need help. We need to fix this. We go to the next slide. So in 2023, Krill did another study, and he found, and this was looking at burnout and predictive suicide risk. And this study, again, very concerning. Lawyers are 22 times more likely to contemplate suicide than their low stress counterparts. And what Krill also realized in this study was that the self-care that we are telling lawyers to go do, while it's very helpful, is not enough. It's not solving the problem. We need more structural changes to the stress quotient. Firms that were trying to, committed to lowering stress, is very difficult within the present structure for them to do it. So lawyers reported that it was basically ineffective. Something else needs to change. One of the other problems that lawyers have, and this affects women even more, is loneliness. Loneliness, if you're lonely, you're 3 times more likely to experience suicide ideation. The A law practice in and of itself creates loneliness since we have to keep things confidential. We can't share with, our friends what's going on for us, and the competition in the workplace probably makes it difficult as well. But women, because we deal with other biases like status quo biases or affinity biases, etc., suffer with other facets of loneliness, and the fact that we oftentimes have other commitments that keep us from being able to engage in social events will create a higher level of loneliness. And the overcommitment. Overcommitted is when what lawyers do, we all want to please everybody all the time. And we say yes to things that we should probably be saying no to. And our culture rewards that. This is a significant factor in deteriorating mental health. We need to learn how to set limits and boundaries, not just for ourselves, but for our business, our expectations of the people that work for us. So we could go to the next slide. So in 2024, Patrick Krill, along with Bloomberg, did another study on well-being, attorney well-being, and what he found was that if you're over 65, if you make it that far, you have a relatively good feeling about well-being in the profession. But the people that have started in the last 10 years are unhappy, very unhappy, which probably explains why they're leaving. You get a little bit better after 10 years and a little bit better after 20 years, perhaps. But the fact of the matter is, the young lawyers that are doing the work are not enjoying it, and they're not going to stick around. And in 2023, the ABA did a presentation, Getting Beyond Bias in the Legal Profession, revealing that women in firms were only 22% of equity partners, despite being 47% of the employees overall. They were only 12% of the managing partners, 28% of the governing committee members, and 27% of the practice group leaders. So not only are women not moving into leadership positions in law, they find their workplace experiences far less satisfying than their male counterparts. 67% of them report a lack of access to business development opportunities, while the men, only 10% of them complained of lack of access. 53% of women have been denied or overlooked for advancement or promotion, compared with only 7% of men voicing the same complaints. And 40% of women report a lack of access to sponsors, compared to only 3% of men. These are the kind of cultural changes that we can make easily once we realize that we have this problem. And the result, of course, is that half of the lawyers are burnt out almost half the time. And I ask everybody, if you knew you were going to go have surgery and you knew 1 out of 2 doctors was burnt out, would you want to have the surgery? Would you take the risk? Consumers deserve better. Lawyers deserve a better workplace environments, but consumers deserve better as well. And the impact of all of this cheery news is that people are leaving 60 and working with cognitive impairments. 62% of lawyers report having seen people, observed other legal professionals who were struggling with substance abuse, mental health issues that were interfering with their work responsibilities. And 48% of us are actively considering leaving or open to offers to leave their jobs. Yeah. So let's dig in. Sorry. Why do people leave? Well, women leave, and this slide got a little bit funny. The first two, high work-family conflict, is just one. Women leave because of high work-family conflict. That is the primary reason why they're going to leave the practice of law or the job that they have right now. The second, men, these are reversed. Men have another rate. Men have leave because of high stress. But both leave, but their second reason for leaving is high work-family conflict. What I think is interesting about this study that Patricia did was the bulk of women are leaving because of work-family conflict, but lack of promotion was not even a top reason for women. And it makes me wonder, is that because it's not even a possibility that they're not concerned about it, which is a very concerning trend. You can go to the next slide. Oh, we're here. So this slide reminded me, I was thinking about Monty Python's Black Knight and how he fought, without an arm, without another arm. He just kept fighting because was that what we consider a good warrior to be? Somebody who will fight to the death. And perhaps that's not an appropriate analysis. They overcommitted, highly stressed lawyer willing to give his body parts to keep on fighting. It's not a viable option today. In fact, the if you never give up, you can't possibly lose philosophy is a pretty unsound philosophy. One might argue dismembering the legal profession limb by limb is not a viable, sustainable practice. So perhaps we need to change our vision of the perfect lawyer or what it is we want out of our people that work for us or the lawyers that are hired. A 2023 ABA bias study found that women continue to face not only the statistical differences in career advancement that we talked about, but also affinity bias, gender bias, outgroup bias, and status quo bias that we spoke about earlier. But we also are still struggling with the Goldilocks dilemma. That dilemma where if women conform to the dominant feminine stereotypes, being warm, pleasant, modest, differential, and concerned about others, they're seen as too soft to be effective leaders, that they don't have, they're looked at as not having ambition and commitment, or the necessary fire in the belly to be able to lead. But on the other hand, if they adopt traditionally masculine behaviors, being assertive and tough, they're likely to be seen as too hard to be effective leaders. This is it's something that we can all talk about and start to recognize that these are not effective stereotypes and they're not what we need in the practice today. And it's not hard to imagine if women are dealing with that every day, in addition to the stresses of a law practice, that it's not a happy place to work. But so what all this data shows us, on to the next slide, is that this is a long-term systemic problem that threatens the sustainability of the legal industry. That the interventions that we've tried of individual interventions for self-care, firm attempts to lower stress levels, lawyer assistance programs, which all states have adopted since 2016, wellness programs, they're not solving the problem. That we have to solve the problem from within, from our cultures within the practice. And on to the next slide. So it isn't just a scratch. All these things, stress, overcommitment, work-family conflict, loneliness, trauma, alcohol consumption for stress relief purposes, are a continuum of the bias that I saw in 1990 and have existed long before, and they lead to a failed business model, depleted and dysfunctional workforce, flawed products that we're producing. The consumers lose trust in our profession, which leads to a failure of the justice system if nobody trusts us. And finally, for me, Patrick Krill, with 10 years of data under his belt, looking at this problem, gave us his vision of the goal we should be aspiring to, which I think is a very important goal to set for all of us. And he said that a career in law should not be antagonistic to the full expression of a lawyer's humanity, including their ability to undertake and navigate familial obligations should they so desire. Strategies and interventions aimed at alleviating work-family conflict would be wise pursuits for legal employers hoping to reduce unwanted turnover and increase the likelihood that their attorneys will be able to thrive across all dimensions of their lives. I think that's a worthy goal that we should all aspire to. Justice Benke?
Yes, thank you. This is a good way to segue. Thank you, Geri, and thank you all for listening so intently. I want to go back to our first slide, the canaries. I don't know all of your ages, but the question is, are we the canaries? And if you don't know it, the canaries were traditionally carried into the coal mines and dangerous spots. And if they died, there was something really wrong inside the tunnel. And that was the first warning of harm about to occur, perhaps significant harm. And so we ask that question, are we harming ourselves to the point that that coal mine, that mine that we are in, is risky? And when we look at the goals, when we segue forward here to the goals and read this last slide, is that not the goal of any profession? The language is very broad. Attorneys are no different in many ways than any other profession that has a lot of pressure on it. The medical profession, for example, has been compared, and what we have found in some of those studies is that the stress levels when doctors first start out are very, very high, comparable to those of lawyers. As they progress, get older, mesh their ways into the profession, they get better. Those stats get better in the medical profession. They do not get better in the legal profession. And so something is wrong, interior to what it is that we do. And so we're looking at a systemic problem as well as those statistics that Geri went through. And they're staggering. The statistics are staggering. And especially the suicide statistic, 10% to 12%. That's an amazing number. And I think, by the time you look at these statistics and multiple studies, it's very difficult to say there's no problem here and turn into the knight that's willing to give up the hands and the arms. There is something wrong. And so the next big question is, what do we do about it? Are there any solutions? Is there hope for the legal profession? And you see there on the slide, the lovely lady standing trying to hold back a flood coming at her. And I think that the answer to that question is yes. There is hope, but there's only hope if first you recognize the problem, and second, that you in the profession, we in the profession, come up with solid ways of dealing with it. And that continuum is marked. That continuum of these well-being issues create the bias. They create the bias, and they do it almost by statistical analysis. The more women who enter the profession, the more individuals who are demanding more than just getting up, going to work, and going home again. They are disproportionately affected by the stresses, by the depression, by everything that we've been talking about in the first part of the program. And they become the weak links, if you will, to keeping the profession healthy. And so at the outset, we talked a little bit about this term bias and who it affects, and Geri talked to that. The question of bias is not just women. The question of bias applies to those who are disproportionately at risk. And the system is a bias system to their happiness. And in return, their unhappiness is disproportionately negative to the profession in general. So the problem is there. And how do we solve it? We can go on to the next slide here. I think it takes us to our list of where we start to determine where do we find help. Well, the trailblazers, if you will, in the profession, and those who set the culture of the profession are very much government agencies, and this includes the courts. I joined the profession of law in 1974, and at that time, we still heard strange stories coming out of courtrooms of the way that women were treated specifically. One very well-known attorney appeared in court, and the court itself asked, "What does the probation officer say about this?" And so that said a lot. That was the early 70s. Government agencies began moving into this question, this problem, I think in the early 80s. As a newbie attorney coming in, I first worked for the Attorney General's office. And the Attorney General's office took a very strong stand as a government agency in welcoming women, welcoming different ways of solving issues. I started working for the Attorney General's office. I was pregnant in 1983. And I went in and apologized because they were considering me for a move up to the Superior Court. And in 1983, I said, "Well, you see, I'm pregnant." They stopped me in my tracks and said, "Okay, we can see that. Now move on to the next question. When can you start work?" And it was a little bit earth-shattering because I did not expect that response. And moving into the 80s, the agencies, all of them, the Department of Transportation, if one talks to individuals who started at about the same time, like Justice McConnell with the Court of Appeal in San Diego was with the Department of Transportation, when these changes were moving through, and a demand to respond to the needs of individuals. When my first son was born, I, at that time, faced a new development in the law. And within the Attorney General's office, you got time off. You had 8 months, 9 months that you could stay home and begin to raise your child. And it was strongly suggested I might want to come in and bring him with me. So I brought Michael with me for about a day, and that was the end of that policy for me. But it was there, it was welcoming, and it permitted diversity of the interests that individuals had. So that began moving forward. When I was appointed to the Fourth District Court of Appeal, one of my children had graduation from preschool, and it was a big deal. So I asked my secretary, paralegal, was she going to her son's? Her son was about my son's age. Were you intending to go? I certainly will give you the time. And she looked at me with this questioning look and said, "I never thought about that." That was something she had never calculated in. But what I realized at that time, that the change in personnel, the changes in our culture were beginning to impact the courts and our agencies. And the courts can still lead by way of example. This has to do very much with the conduct of judges and court personnel. Are judges welcoming? When a problem arises in the courtroom, are judges able to open their minds to creative ways to solve it? And so conduct of judges and court personnel set the tone, if you will, and the culture that's so important in our profession. They further need the acceptance of the needs of attorneys in general. For example, caregivers that respond to demands. Caregivers, lots of women statistically, but others as well. And the law is beginning to change with respect to this concept of caregiving. It's broader, and it's finding its way in. So when one looks at the progress of the courts and agencies, it looks pretty good. And those of us who've been around for a while have seen this. Now let's talk about law firms. We can go to the next slide. It's,
Before you go to
yes,
the parts, I think that that's very hopeful. Your vision that you're presenting there, and I really hope that state and federal courts adopt this. And I think it's more than an ethical fairness issue that we have talked about bias about in the past. It is a culture, and if the courts, from my practice, if the courts start adopting a different culture, if the courts don't go, yeah, all trials start at 7 o'clock in the morning, which really negatively impacts any caregiver, because what do you do with your kids at 7 in the morning to be in court?
right.
There's things that once we understand that this is an issue, that the people that are doing the work are no longer footloose and fancy free. They can be there whenever the court wants them there. And that we have to think about the families as a whole, like in the other first responders and whether it's police, law enforcement, or military, that the family is considered as well part of the workforce here, that we can start to make some progress.
Yes, and something I thought that you said was very interesting, that this question of bias, things automatically pop into your mind when you hear that word. But we're not really talking, if we're really going to dig in and solve some of these issues, we're not really talking about an ethical issue or issues, just ethics. We're talking about systemic response. What do we do as courts? What do we do as agencies? And what do we do as law firms? And there's a lot that can be done. Some of the suggestions that have been made are establishing codes of acceptable behavior in especially large law firms, but sometimes in smaller law firms as well. Things as simple as, at least in naming, maybe not much in dealing with microaggression, the little things that happen in the workday, the little things that happen because. And and so formal processes can be established for example, how are assignments given out? What type of assignment protocols are there that allow everybody to feel that they are part of the law firm um, and part of the profession? Providing different tracks for individuals. And we started doing that a while ago with the larger law firms, I think, somewhat leading the way by saying, look, if you don't want to be a partner and you're not interested in partner track right now, because you do want time at home, you do want to be able to respond to the other things that are putting pressures on you, then don't go a track that is going to demand that. We're going to provide you with alternate tracks, a non-partnership track. Guess what? We're going to have on the premises childcare. That was quite a subject of several movies, but that as well just changes within the law firm for the processes, providing different tracks, balancing work levels, balancing the work of teams, the team concept involves, I think, if a team is going to work well, we know that the team has multiple talents, and they don't always include the same talents, the same hours that are necessary to work. Um, Restructuring of evaluation processes, um, and adopting a culture, making efforts to adopt a culture. that is important. That whole list up there, you could probably sit back in your law firm. You might be able to sit back and say, okay, we're going to brainstorm once a year. What can we do? What types of structure? And I emphasize that word structure as being very important. Now, there
Yeah.
have been, yeah,
So one of the things that, or some of the things that we've seen at the incubator, and in looking into these issues of what can be done and how can we have a healthier, is this is a gender issue or a bias issue? It's a health of the practice issue. How do we make it healthier? And one of the things, thinking about job sharing, thinking about when you're balancing the work teams, also balancing the money. So we traditionally pay, if you divide the jobs into finder, minders, grinders, we pay the finders that go out there and get business generally more than we pay the people doing the work or my supervising the people doing the work. And those jobs are at either different parts of your life work better or for different types of people. If you're in the period of your life where you're raising kids and have to be at a pickup at school at 6 o'clock at the latest, you can't be flying all over the world networking and making relationships to find business, but you can sure be at the office supervising younger attorneys being, in their pursuits or doing the work yourself. And then at different parts of your life, you might want to get on a plane and go network. But the idea that we are stuck in the field and that the money isn't equitably shared among all of the parts of the profession of the team is one of the big problems.
right. And responding creates happiness, and happiness creates effective leadership. It creates effective work product. I was on the Fourth District Court of Appeal for just about 35 years. And I only had one staff. I had a couple people retire, but they stayed the whole time I was there, and we were quite a close family. That's not a unique experience, I think, on the courts. But I very early in my career decided that I wanted my attorneys and staff to be happy. One of my attorneys worked best at 6 a.m. He came in at 6 a.m. in the morning. After 2 o'clock, sometimes he couldn't think straight. That's when he went home. Um, at about noon, my second attorney came in, and he loved to work until very, very late in the evening, sometimes 10 o'clock. I could call my chambers, and there he would be, and I would be able to talk with him. And I always thought that was wonderful because I had a chambers that operated from 6 a.m. to about 10 a.m. every day, 10 p.m. every day. They were very happy. I was happy with their work product. But that's not a model that is unique. I think those kind of creative ways of dealing with people is very, very important. I don't want to escape without mentioning the work of Stuart Teicher, and that's spelled Teicher. He is a professor of what he calls technethics. It's the technical part and it's the ethics part put together. And what he did is he went down to the Mississippi Delta, um, took that geographic area. And in his presentations, he speaks a lot about the history of the area, how important it was to the blues music industry and the talent that came from that region. And he speaks to why it dissolved and the people went away. And it smacks very strongly of any business model that stops working. And what he speaks to is the loss of a thriving community due to a lot of the aspects that we're talking to today. And at the end of his comments is when he starts talking about the legal profession and how very close what he saw impacts the health of the legal profession and the businesses. And he paid very special attention to something law firms can do. They always have. Many of them profess to. The courts have professed to, but they don't truly do it. And that is mentoring. And he speaks of mentoring as more than call me if you need me. He talks about mentoring as law firms, individuals in law firms reaching out to new attorneys, pulling them in and teaching them how to be good attorneys, not just responding, but being actively involved. And those special problems that he lists are, at the top of it is mentoring. And I would ask attorneys who are here from large law firms, especially, do you have mentoring? And I guess everybody's going to say, yes, I have mentoring too in my office. And what do you do as a mentor? How do you pull people in? And that is a special problem given the remoteness now of law work and the problems that many associates face and law firms face, that throughout the COVID experience, personal attachment, personal conduct toward one another, learning how to deal with one another, and bringing people into your family of lawyers is so important and was impacted, yes, nicely in some ways, very badly in other ways. And law firms that at least are my personal experience that I know of now are beginning to call lawyers back. You can't go home and look out the window while you're working. You're going to need to be at at your desk, working, providing all the personal things. If you don't do that, and if you begin to separate, I don't want to sound preachy here, what happens? What happens is all of those bad things that we talked about, the depression, the loneliness, they take a special role in not being part of. So I think that struck me. That was very, very, very important to talk about the COVID effect.
Yeah, and I'd like to add on to that as well. The remote work creates the need to actually work harder at mentoring. I grew up in the courtroom. I was a trial lawyer and courtroom lawyer from the beginning. I learned what I needed. I learned by being in the courtroom for all of my motion practice, for everything. I was there. I saw other lawyers doing things. I got mentored, made friends, made relationships and saw how judges behave and act and learned my craft by being there. Today, 90% of the appearances in California remain remote, which means lawyers are not, and courts are working hard. And now that the judge pro tems don't want to come in, the various different people don't want to come in. The courtroom is no longer a place that avails itself to young lawyers learning the craft. So we have to work harder outside of the courtroom to teach them because they can't learn there anymore. At least
Sure.
not now.
And you might entertain the ways you can do this within a particular firm, a particular group of people. What was the takeaway that I had from the studies and the Mississippi Delta study was that down in the Mississippi Delta was no different than any business model. It stopped being inclusive. It stopped mentoring. All the things we talk about developed, and that wonderful business disintegrated. It went elsewhere. And isn't that the question going to business model? Any business model. If you impose on it the stresses and strains that we've been talking about, it goes away. It goes away within a firm or within an agency or entity, and it goes away as a system. So we're talking about systemic approaches to solving issues, having bar associations responsive, inviting individuals with issues to come to them. But it also involves the internal structures of how we deal with the law in law firms, which is what we have been talking about. And so I might want to leave it there, Geri, unless you have something else you want to add, because the first part, we talked about the issues. It cannot be denied statistically. The second part, we're talking about what do we do about it? What can you do about it individually, those of you who are listening, as well as leaders in the profession?
I mean, I
And
think there are a couple more things to add. Concerns that I have are that um, I read something recently where one of the tech guys is going to start a new business model where his workers are working 84%, 84 hours a week. We need to be very careful about how we look at workers today, and make sure that we're, our our profession is not falling prey to that kind of
Yeah.
analysis, because
Right.
84-hour work weeks is not, I mean, we may be doing that because we have to right now and we're trying to change it, but the idea that that's a model we're going towards as a realistic way of producing anything is very concerning.
Yes, I absolutely agree. And it's possible you might work 84 hours in a week because you're happy doing what you are doing. And that's what you want to do from 8 to 5 o'clock or later every day, including Saturdays and Sundays. But that's self-imposed, if you will, not because you're unhappy. The point is to create a happy employee that wants to do that. Um, of course, you're leaving a lot of things out if you are doing it. This is a good time, I think, and a good point to segue into okay, we've got our system, we've got our traditional business model. How do we improve that business model and make it do what it ought to be doing? But there are other business models and they are being used. And if I can put in a plug here for ADR, I'm going to do it because, this is a good time to do it. ADR is its own method of solving disputes. It's a unique way of solving disputes. It does not use billable hours. It does, but in a much softer way, a more general way, because you've got a bill. But it provides something different than the traditional solving of disputes. So I see that as not as a substitute, but as a model that can help resolve disputes. And the second one, I'm going to say this.
Well, and but and of course,
Yeah.
resolving the disputes and getting it off your table, off your desk,
Yes.
is stress relieving in and of itself.
Yes.
And using mediators that in cases where it makes sense, that will help you, will be a partner for you in marshaling a case through to resolution, so that it doesn't have to weigh on your soul and be a cost suck
Yep.
in every way, shape, and form is a way that I see mediation and neutral work going today, as opposed to waiting till the end of the case and going into mediation, getting there early, understanding that it's a path. It might not settle early on, but you can use the mediator throughout the case as your partner to get things done.
Yes. Yes. And the process of going all the way through discovery, lots and lots of discovery with all of its tensions, costs, and stresses. Um, Traditionally, not tradition, I'm not going to use that word, but then it ends on, well, we can't solve it. What are we going to do before we go to trial? And if you move that up in time to evaluate the case, is it going to go to trial, or are we going to spend all of our time and resources in discovery and do that earlier in the process? And individuals can do that. Businesses can do that on their own. This is a dispute I'm having with an employee. Do we need to solve it in the trial court? Can we solve it by way of an alternate process? There are also other, and so harkening back to the major theme of what we're saying is that ADR is not alternate. ADR is a co-equal process of solving disputes. And secondly, um, we've got what I call the traditional model, an alternative model, alternative dispute resolution. And within firms, can they be structured so that it's non-traditional, if you will? There are law firms. Complex appellate litigation is a group that uses, and other groups do as well, a contract, independent contracting. And the individuals who solve the disputes, much like ADR, um, operate independently, so that you structure your work around the time available, your children, your profession, all of those. But this idea that ADR is something you go to when the process doesn't work is something we can maybe move away from culturally, to saying some disputes shouldn't be on a train track to trial. They should be on a train track to either agreement, or if you can't agree, at least you could be friends in the end and leave with what is fair.
Well, and the fact of the matter is 99% of cases today are going to settle at some point, right? The very, very, very few of them end up in the trial courts. But that doesn't mean you shouldn't prepare your cases if it's going that way, because that's what makes the best settlements is if you're ready to go to trial, your case usually settles a lot better than if you were ready. But thinking about it, that if it's going to end up there, set the case up to go there and keep your costs down in every way you can. As you were talking, I was thinking about the reason that I went to law school was because I like to resolve disputes, but I realized as a woman, I did much better in a courtroom than I did out in the street. I wasn't, it leveled the playing field to the extent that I could be heard and fight the battle, in a courtroom and I was much better placed than where I needed brawn. And I see that in alternative dispute resolution as well. It's actually set up to be more cooperative, more working together to solve the problems. Even if you're battling with each other, there's some sort of shared understanding that we're here to help to try and resolve it. And so the prisoner's dilemma that was talked about earlier today, that the idea that people are cooperating, at least in the theory, that we're going to try to resolve this dispute. And trial is a dispute resolution methodology. It's just, and so is war. It's just not necessarily the best one for most disputes. So, I think that bias gets, the bias levels out a little bit in a more neutral situation like mediation and ADR.
I have nothing more to add. That's a good end.
We do have a couple of questions here, a couple of which I thought were particularly interesting and relevant to your program. You both spoke about mentorship and how important that is. It strikes me that with kind of the switch to so much remote work, there's a real responsibility on more senior attorneys who probably haven't been prepared to mentor people under these conditions. So that's a real responsibility for them. How could senior attorneys go about mentoring younger attorneys and maintaining this more solid pipeline and not disrupting this continuum?
Well, much like teaching remotely, what we have found is that statistically, the more you talk with your students, the better off you're going to be, the better the class is going to be. And I'd say if someone's working remotely, you put your hand on their shoulder by whatever way you can communicate, and make a specific assignment. I am your mentor. You're not going to call me only when you need me. I'm going to check in with you once a week and see how it's going. Ask what the problems are. So it just puts a bigger communication burden, I think, on the seniors in law firms.
Well, and I would also add that because our generations between senior attorneys and younger attorneys, so much has happened. We know a different type of living and law practice than they do. We're actually mentoring them, but we need them to mentor us. We need them to help us learn about AI, learn about tech, learn about how we use these things. And we need to help them learn about how to be responsible lawyers, good at this craft. It is not a one-way street today. It's not that we're just teaching them how to, I'm going to show you, kid, how to go into a courtroom and do this. You need to tell me how to talk to all of your friends, all your people. How do I communicate with people your age? Because it's very different now. So the idea of the mentor-mentee methodology can really help senior lawyers understand that they benefit from doing this.
Yes,
not just a one-way street.
It is. I can't tell you how many friends, just in speaking, have talked about new lawyers, the salaries. I think attorneys should make very good salaries, but it's a way of taking hold again of the legal profession. It's a way of letting individuals know coming in there are rules to follow. And, I appreciate that you want an office at the corner right now, or you're not coming back to the office. And we really want you, so we're going to move you into that corner office if we can do it. Those kinds of subtle demands are out there. And it not only assists the attorney to take hold of them, it assists the firm as well, or the individual they're working for, because you can't solve these issues, particularly with mentoring, without being the person who does the mentoring. And I think that's very important that the structure be a proper one, be properly balanced.
Exactly. Oh, and I didn't think we would get to this point, but it made me think that there is a movie. Anybody interested in mentoring in this idea set should see, if you haven't seen it, it's Robert De Niro's movie, The Intern, where he retires and goes back and he's an intern and he is learning that I don't know what I'm teaching them, but mostly they're teaching me. And this idea that it's a two-way street can go a long way to forging those relationships that both people are benefiting by.
Right. And I have a lot of respect for the power structures, because power structures have to be. They have to exist. And being the mentor does mean being in charge.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.